I was standing in my bedroom with a paint roller in my hand when the doorbell rang 3 times in rapid succession, the kind of aggressive ringing that made my teeth clench. It was a Saturday morning in Phoenix, Arizona, and I had finally taken the day off from my consulting job to repaint my bedroom walls from the builder's beige to a nice charcoal gray. The paint cans were open, the drop cloth was spread across the hardwood floor, and I was ready to transform this space into something that actually felt like mine. I set the roller down and headed to the front door, wondering who could possibly need something at 8 in the morning. When I opened the door, I found myself face to face with a woman in her mid-50s wearing a pristine white polo shirt with an embroidered logo that read, Sunset Ridge HOA Board President. Her blonde hair was cut in that aggressive bob that seemed to be standard issue for a certain type of person, and her lips were pressed into a thin line of disapproval. She held a clipboard against her chest like a shield. "Can I help you?" I asked, trying to keep my voice pleasant despite the interruption. "Are you Gregory Vance?" she asked, her tone clipped and officious. "I am. What's this about? I'm Deborah Mitchell, president of the Sunset Ridge Homeowners Association Board. I received a report that you're conducting unauthorized modifications to your property without proper approval from the Architectural Review Committee." I stared at her for a moment, genuinely confused. "I'm sorry, what? I'm painting my bedroom, inside my house." Deborah's eyes narrowed. "All modifications, interior and exterior, require written approval from the HOA per the covenants, conditions, and restrictions you agreed to when you purchased your home. Did you submit an architectural review application for your painting project? You're joking, right?" I let out a short laugh, but Deborah's expression remained completely serious. "You think I need HOA approval to paint the inside of my own bedroom?" Section 12, subsection 4 of the CC and Articus clearly states that any modifications to the property, including paint color changes, must be approved in writing before work begins. This applies to both exterior and interior modifications to maintain neighborhood standards and property values. I felt my blood pressure rising. I had bought this 3-bedroom ranch house in the Sunset Ridge development 6 months ago, and while I knew there was an HOA, I hadn't paid much attention to the fine print. Like most people, I assumed HOA rules covered things like lawn maintenance, exterior paint colors, and whether you could park an RV in your driveway. The idea that they thought they had jurisdiction over what I did inside my own home was absurd. "Look, Deborah, I appreciate you stopping by, but I'm painting my bedroom. This doesn't affect anyone else in the neighborhood. Nobody can even see inside my house." "That's not the point, Mr. Vance. The point is that you entered into a legally binding agreement when you purchased your home. The rules exist to protect everyone's property values, and they must be enforced uniformly. I'm going to need you to cease all work immediately and submit the proper paperwork for review." The Architectural Committee meets on the 3rd Thursday of each month, so you can expect a decision within 30 to 45 days after your submission. 45 days to get permission to paint my own bedroom. I could hear my voice rising. This is insane. I'm not stopping. I'm painting my room today, and there's nothing in any reasonable interpretation of property law that gives you the authority to stop me. Deborah made a note on her clipboard with a very deliberate motion. "I'm documenting your refusal to comply. You'll be receiving a formal notice of violation within 5 business days. The fine for unauthorized modifications is $200 per day until the violation is corrected or proper approval is obtained. I strongly advise you to reconsider your position." She turned on her heel and walked back to her silver Lexus parked at the curb. I watched her drive away, absolutely stunned by what had just happened. I stood there for a full minute trying to process the conversation before I went back inside and picked up my phone. My best friend Marcus worked as a paralegal at a law firm in downtown Phoenix, and while he wasn't an attorney himself, he knew more about real estate law than most people I'd met. I called him immediately. "Hey man, what's up?" Marcus answered on the second ring. "I need to run something completely insane by you. The president of my HOA just showed up at my door and told me I need written approval to paint my bedroom." "My bedroom, Marcus. Inside my house. She said I'm going to be fined $200 a day if I don't stop and submit paperwork for approval." There was a pause on the other end of the line. "Wait, back up. She said you need approval for interior paint." "That's exactly what she said. Something about Section 12 of the CC and Articles, saying all modifications need approval, including interior paint changes." "That's completely insane. Hold on, let me get to my computer. Can you send me a copy of your CC and Articles?" I spent the next 20 minutes digging through my home purchase documents while Marcus waited on the phone. I finally found the thick packet of HOA documents and scanned through until I located Section 12. I read it aloud to Marcus. "All modifications to properties within Sunset Ridge, including but not limited to structural changes, landscaping alterations, exterior paint color modifications, and decorative additions, must receive written approval from the Architectural Review Committee prior to implementation to ensure compliance with community standards." "Read that again, slowly," Marcus said. I read it again, paying closer attention to each word. "Oh, it says exterior paint color modifications, not interior." "Exactly. It specifically says exterior. The only interior item even mentioned is structural changes, which painting absolutely is not. Your HOA president is either completely incompetent or deliberately trying to overstep her authority. Either way, she's wrong." "So what do I do?" "She said I'm getting a formal violation notice. You let her send it, and then you respond in writing explaining exactly why she's wrong. Better yet, you should probably talk to an attorney. The firm I work for has a partner who specializes in HOA disputes. His name is Richard Chen, and he's really good. He actually enjoys taking on HOA boards that get too big for their britches. You think I need a lawyer for this?" "It seems excessive." "Gregory, she threatened to fine you $200 a day. That's $6,000 a month for painting your bedroom. You absolutely need a lawyer. Want me to set up a meeting?" I agreed, and Marcus said he'd talk to Richard Chen on Monday morning. I spent the rest of Saturday finishing my bedroom, painting all 4 walls a beautiful charcoal gray that made the white trim pop. Every stroke of the roller felt like an act of defiance. By Sunday evening, my bedroom looked fantastic, and I felt satisfied with my work, even as I wondered what kind of absurd battle I was getting myself into. The formal violation notice arrived on Wednesday, exactly as Deborah had promised. It came in a certified letter that required my signature, and the contents were even more ridiculous than our doorstep conversation had suggested. The notice claimed I had violated multiple sections of the CC and Articles by making unauthorized modifications, that I was harming property values throughout the community, and that I owed a fine of $200 per day starting from the Saturday when Deborah had first observed the violation. They helpfully calculated that I already owed $1,000 for the 5 days since her visit. The notice also informed me that I had 15 days to respond in writing, after which the HOA would place a lien on my property for the unpaid fines and potentially foreclose on my home to recover the debt. I read that last part 3 times, certain I must be misunderstanding something. They were threatening to take my house because I painted my bedroom. I called Marcus immediately, and he arranged for me to meet with Richard Chen that Friday afternoon. The law offices of Chen and Associates occupied the 12th floor of a modern glass building in downtown Phoenix, with a reception area that had floor-to-ceiling windows overlooking the city. Richard Chen turned out to be a man in his early 40s with wire-rimmed glasses and an easy smile. He invited me into his office, which was lined with bookshelves full of legal texts and framed newspaper articles about various cases he'd won. "Marcus filled me in on the basics," Richard said as we sat down. "Why don't you walk me through exactly what happened from the beginning?" I told him everything, from Deborah's surprise visit to the threatening letter I'd received. Richard listened carefully, occasionally making notes on a yellow legal pad. When I finished, he asked to see the violation notice and my CC and Artiques. He read through both documents in silence for several minutes. Then he started laughing. It wasn't a polite chuckle or a restrained laugh. Richard Chen actually laughed out loud, the kind of genuine amusement that made him take off his glasses and wipe his eyes. "I'm sorry," he said, still grinning. "This is just incredibly absurd. Your HOA president has either never actually read your CC and Artiques, or she's deliberately trying to intimidate you into compliance with rules that don't exist. This is one of the most clear-cut cases of HOA overreach I've seen in years. So I'm not crazy. I don't need their approval to paint my bedroom." "You absolutely do not need their approval. The CC and Artiques are very specific about exterior paint modifications. There's no reasonable interpretation of this language that extends to interior paint. Moreover, even if the CC and Artiques did claim jurisdiction over interior paint choices, that provision would be legally unenforceable. Arizona law is very clear about the limits of HOA authority. They can regulate external appearance and common areas, but they cannot dictate what you do inside your private living space as long as it doesn't affect health, safety, or the external appearance of the property." Deborah made it sound like I agreed to give up all my property rights when I bought the house. That's a common tactic used by overzealous HOA board members. They rely on homeowners not understanding their rights or not wanting to fight back. Most people just comply rather than deal with the hassle, which reinforces the board's belief that they can do whatever they want. But you have every legal right to paint your bedroom any color you choose, and no HOA in Arizona can stop you or fine you for it. Richard leaned back in his chair. "Here's what I'd like to do. I'm going to draft a formal response to this violation notice explaining in detail why the HOA's position is legally baseless. I'll cite the specific language in your CC and Artiques, reference Arizona HOA statutes, and include case law that supports your position. I'll also demand that they rescind the fines and cease any further action on this matter. If they're smart, they'll back down immediately. And if they're not smart, then I file a complaint in Superior Court alleging harassment, abuse of authority, and violations of Arizona's planned community statutes. We ask the court to invalidate the fines, award you attorney's fees and costs, and potentially impose sanctions on the HOA board for bringing a frivolous action. Depending on how badly they want to play this, we might also seek damages for emotional distress and an injunction preventing them from similar overreach in the future." "How much is this going to cost me?" Richard waved his hand dismissively. Arizona law allows prevailing parties in HOA disputes to recover their attorney's fees from the losing side. Given how clear-cut this case is, I'm confident we'll win, which means the HOA will end up paying my fees. I'll need a retainer up front, but you'll get it back when we prevail. Call it $3,000 to start, and I'll keep detailed records of all time spent." I thought about it for maybe 10 seconds. The principle of the thing mattered more than the money at this point. I wasn't going to let some power-hungry HOA president think she could bully me into accepting her fictional authority over my private life. "Let's do it," I said. Richard's smile widened. "Excellent. I'll have the response letter drafted by Monday. This is going to be fun." I left the law office feeling vindicated and energized. For the first time since Deborah had shown up at my door, I felt like I had some control over the situation. That weekend, I went about my normal routine, enjoying my newly painted bedroom and trying not to think about the absurdity of what was happening. Richard's response letter went out the following Tuesday via certified mail. He sent me a copy, and reading it was deeply satisfying. The letter was 6 pages of precise legal language that methodically dismantled every claim in the HOA's violation notice. Richard quoted directly from the CC and Articus, showing how the language specifically referred to exterior modifications. He cited Arizona revised statute sections about the limits of HOA authority. He referenced court cases from Arizona and other states where HOAs had tried to regulate interior paint colors and had been firmly rejected by judges. The letter concluded with a demand that the HOA rescind all fines, issue a written apology, and refrain from any further action related to my interior paint choices. It was a thing of beauty. I expected a quick response from Deborah, probably backing down and making some excuse about a misunderstanding. Instead, I got silence. A week passed with no word from the HOA, then 2 weeks. Richard said this was actually a bad sign because it suggested they were digging in rather than admitting their mistake. "Reasonable people respond quickly to admit an error," he explained during a phone call. "When they go silent, it usually means they are either consulting their own attorney or they're too stubborn to back down, even when they know they're wrong. Either way, we need to be prepared for this to escalate." On a Thursday afternoon 3 weeks after Richard sent his letter, I came home from work to find another certified letter from the HOA. This one was even thicker than the first. Inside was a formal notice that the Architectural Review Committee had reviewed my case and denied my after-the-fact application for interior paint modification. The letter stated that because I had failed to obtain prior approval and had refused to cease the unauthorized work, my fines had now accumulated to $8,400. They were placing a lien on my property effective immediately and would begin foreclosure proceedings if the fines were not paid within 30 days. The really outrageous part was that I had never submitted any application to the Architectural Review Committee. They had apparently decided to treat Richard's response letter as an application and had formally denied it. It was a completely absurd legal fiction, but it allowed them to claim they had followed their own procedures. I called Richard immediately. When I read him the letter, he was quiet for a long moment. "Well," he finally said, "I think they just made a very expensive mistake. They've now put in writing that they're asserting authority over interior paint colors, and they've taken concrete action by placing a lien on your property. That gives us everything we need for a complaint. I'm filing tomorrow. What exactly are we asking for?" "We're going to ask the court to remove the lien, invalidate all fines, declare that the HOA has no authority over interior paint colors, award you attorney's fees and costs, and impose sanctions on the HOA board members personally for pursuing a legally frivolous action. We might also seek damages for the stress and harm this has caused you." Can you really go after the board members personally? Under Arizona law, yes. HOA board members generally have immunity for good faith decisions made in their capacity as board members. But that immunity disappears when they act in bad faith or pursue actions they know or should know are legally baseless. I sent them a letter with extensive legal authority explaining why their position was wrong. They ignored it and doubled down. That could be considered bad faith, which would expose them to personal liability. Richard's complaint was filed in Maricopa County Superior Court that Friday. It was a 30-page document that laid out the entire situation in meticulous detail. Richard named both the Sunset Ridge Homeowners Association and Deborah Mitchell personally as defendants. The complaint alleged abuse of authority, harassment, violations of Arizona's planned community statutes, breach of fiduciary duty, and intentional infliction of emotional distress. We asked for the lien to be removed immediately via a temporary restraining order, with a preliminary injunction to follow, and for a declaration that the HOA's actions were unlawful. We also requested attorneys' fees, costs, and damages to be determined at trial. The filing made me nervous. I'd never sued anyone before, and taking on my HOA felt like declaring war on my own neighborhood. But Richard assured me we were on solid legal ground, and more importantly, that we were doing the right thing. HOA boards need to be held accountable when they overstep, he explained. If you back down, Deborah will keep doing this to other homeowners. You're not just fighting for yourself, you're fighting for everyone else in your community who might face similar harassment. The court granted our request for a temporary restraining order within 48 hours. A judge reviewed our complaint and the supporting documents and issued an order preventing the HOA from taking any foreclosure action while the case was pending. The order also required the HOA to file a response to our complaint within 20 days. I didn't hear anything from Deborah or the HOA for 2 weeks, and then I started noticing strange looks from my neighbors. People who used to wave when I got my mail now looked away or hurried inside their houses. I ran into my next-door neighbor Tom at the mailbox one afternoon, and he actually crossed the street to avoid me. It took me a few days to figure out what was happening. Apparently, Deborah had sent a letter to all Sunset Ridge homeowners explaining that someone was suing the HOA over reasonable community standards, and that if we lost, everyone's HOA fees would increase dramatically to pay the legal bills. The letter didn't name me specifically, but in a neighborhood of only 72 houses, it didn't take long for word to spread. I found a copy of the letter stuffed in my mailbox one day, presumably from a neighbor who thought I should see what was being said about me. Deborah's letter painted me as a troublemaker who cared more about my personal preferences than the good of the community. It claimed that if residents were allowed to make modifications without HOA approval, the neighborhood would descend into chaos and property values would plummet. The letter conveniently left out the fact that we were talking about interior paint colors that nobody else could even see. The social isolation was harder to deal with than the legal battle. I'd moved to Sunset Ridge hoping to become part of a community, to get to know my neighbors and put down roots in Phoenix. Instead, I was being treated like a pariah because I'd had the audacity to challenge Deborah's authority. A few times I thought about giving up, just paying whatever fine they wanted and moving on with my life. But every time I had that thought, I got angry all over again. This wasn't about paint colors anymore. It was about whether someone like Deborah Mitchell could use an HOA board position to bully people into submission. The HOA's response to our complaint arrived on day 19, cutting it close to the deadline. Their attorney was a man named Philip Brandt from a firm that specialized in representing HOAs. His response denied all of our allegations and asserted that the HOA had absolute authority to regulate any modifications within the community, interior or exterior. He argued that my purchase of the home constituted agreement to all HOA rules, that the architectural review process was clearly stated in the CC and Articles, and that the fines were appropriate consequences for my willful violation of community standards. Reading Philip's response was surreal, because it seemed to exist in an alternate reality where words didn't mean what they normally meant. He repeatedly claimed the CC and Articles gave the HOA authority over interior modifications, but when Richard and I read the actual text, it absolutely did not say that. Philip was essentially arguing that all modifications meant all modifications everywhere, including inside your home, while ignoring the specific language about exterior paint color modifications. "This is what I expected," Richard said, when we reviewed the response together. "They've committed to their position now, which means they can't back down without admitting they were wrong from the start. We're going to trial. How long will that take? In Maricopa County, probably 6 to 9 months to get a trial date. But I'm going to push for a preliminary injunction hearing in the next month or two. That's where we ask the judge to rule that the HOA can't enforce the fines or lien while the case is pending. If we win that hearing, it'll put a lot of pressure on them to settle." The preliminary injunction hearing was scheduled for March 15th, a cold Tuesday morning that felt more like winter than spring. Richard and I arrived at the courthouse early and went through security before finding our assigned courtroom on the 3rd floor. Deborah was there with Philip Brandt, sitting on the opposite side of the gallery and pointedly not looking in my direction. The judge was a woman named Sandra Kowalski, who had a reputation for not tolerating nonsense. She called our case right at 9 o'clock and invited both attorneys to approach the bench. Richard presented our argument first, walking through the CC and Articles language and explaining why the HOA's interpretation was legally unsupportable. "Your Honor, the CC and Articles specifically state that exterior paint color modifications require approval. The language is unambiguous. There is no mention of interior paint colors, and under basic principles of contract interpretation, we cannot read terms into an agreement that aren't there. Moreover, Arizona case law is clear that HOAs have limited authority over private living spaces. The association cannot regulate activities inside a home unless those activities create external effects or genuine health and safety issues. Mr. Vance painting his bedroom gray affects no one, creates no external impact, and falls squarely outside the HOA's legitimate authority." Philip Brandt stood up and tried a different approach. "Your Honor, the CC and Articles state that all modifications require approval. The word all is comprehensive and doesn't create exceptions for interior versus exterior. The association has a legitimate interest in maintaining standards throughout the community, and part of that interest extends to interior conditions that could affect future resale values and overall community appeal." Judge Kowalski interrupted him. "Counselor, are you seriously arguing that an HOA in Arizona has the authority to regulate what color someone paints their bedroom?" "Yes, Your Honor. The homeowner agreed to this authority when he purchased the property and accepted the CC and Articles." "Show me where in the CC and Articles it says the HOA can regulate interior paint colors." Philip flipped through the documents, settling on Section 12. "Right here, Your Honor, it says all modifications require approval." It says all modifications, including exterior paint color modifications. If the drafters meant to include interior paint, why did they specifically call out exterior paint? The word including indicates examples, not an exhaustive list. Judge Kowalski leaned back in her chair and looked at Philip over her reading glasses. So your position is that this HOA can tell homeowners what color to paint their bedrooms, bathrooms, and kitchens? Can they regulate what color towels you hang in your bathroom? What color sheets you put on your bed? Those would not be modifications, Your Honor. But painting a room would be. Yes, Your Honor. I'm going to stop you there, Counselor, because this argument is going nowhere. I've read the briefs. I've read the CC and Artiques. There is no reasonable interpretation of this document that gives the HOA authority over interior paint colors. Mr. Chen, I'm granting your motion for preliminary injunction. The HOA is enjoined from enforcing any fines related to Mr. Vance's interior paint choices, and from taking any action on the lien. We'll set this for trial, but I'm strongly suggesting that the parties attempt to reach a settlement because I think we all know how this is going to end. I felt a wave of relief so intense it made me dizzy. Richard shook my hand and we walked out of the courtroom together while Philip huddled with Deborah on the other side. I could see her face had gone red, her jaw clenched in anger. That went even better than I hoped, Richard said once we were in the hallway. Judge Kowalski basically ruled from the bench. Even if we go to trial, we have her preliminary finding on record. This is a huge win. Do you think they'll settle now? I don't know. A smart HOA board would absolutely settle. But Deborah Mitchell doesn't strike me as someone who accepts defeat gracefully. We'll see. We didn't have to wait long for an answer. 3 days after the hearing, Philip Brandt called Richard and proposed a settlement. The HOA would agree to rescind all fines and remove the lien if I would agree to drop the lawsuit, and sign a release preventing any future legal action related to this matter. They would not, however, admit any wrongdoing or pay my attorney's fees. Richard relayed the offer to me over the phone. What do you think? They want me to pay your fees even though we won the injunction hearing. That's what they're proposing, yes. It's a fairly typical opening offer. They're hoping you'll decide it's not worth fighting over a matter of principle. How much are your fees so far? About $12,000. If we go to trial, figure another $20,000 to $30,000 depending on how long it takes. I thought about it for a long minute. $12,000 was a lot of money, but the principle still mattered. I want them to pay your fees and issue a formal policy clarification that they have no authority over interior paint colors. If they do that, I'll drop the personal claims against Deborah and call it even. Richard conveyed my counteroffer to Philip, and we went back and forth for 2 weeks. The HOA didn't want to pay attorneys' fees because they claimed they had acted in good faith and simply disagreed about the interpretation of the CC and Artiques. I wasn't budging on that point because I wanted there to be real consequences for what they'd done. The negotiations finally broke down in early April. Philip called Richard and said the HOA board had voted to reject settlement and proceed to trial. They were prepared to spend whatever was necessary to defend their authority to enforce community standards. It was clear that Deborah had convinced the rest of the board that this was a hill worth dying on. Okay, Richard said. Then we go to trial and we add a few more claims. I'm amending our complaint to include requests for punitive damages and to add claims against the other board members individually. If they want to play hardball, we'll play hardball. The amended complaint was filed on April 15th, and this time it named all 5 members of the HOA board as individual defendants. Richard alleged that they had violated their fiduciary duties to the homeowners, acted in bad faith, and caused intentional emotional distress. We were now seeking $50,000 in compensatory damages, punitive damages to be determined by the jury, all attorneys' fees and costs, and a declaration that the entire board should be removed from their positions. That amended complaint got people's attention. I started receiving anonymous letters at my house, some supporting me and others calling me terrible names. Someone spray-painted HOA hater on my driveway one night, which was ironic because I had to get the graffiti removed to comply with actual HOA rules about property appearance. Two of the board members, a couple named Brian and Susan Thorne, contacted Richard privately and said they wanted out. They hadn't understood what Deborah was doing when she brought the action against me, and they certainly didn't want to be held personally liable for her vendetta. Richard worked out a deal with the Thornes' attorney. They would resign from the board, provide depositions about what had happened behind the scenes, and be dismissed from the lawsuit in exchange for written statements about Deborah's behavior. It turned out that Deborah had presented my interior paint project to the board as a major threat to community standards, without mentioning that it was interior paint. She told the other board members that I was painting my house exterior without permission and being hostile to reasonable HOA authority. The Thornes had voted to support the violation notice based on Deborah's misrepresentation of the facts. This was huge for our case. It showed that Deborah had deliberately misled her own board in order to pursue action against me. That went straight to the question of bad faith and made her personal liability much more likely. The discovery process dragged on through spring and into summer. Richard subpoenaed all of the HOA's records related to my case, as well as records of other enforcement actions they'd taken over the past 5 years. What we found was disturbing. Deborah had been president of the Sunset Ridge HOA for 4 years, and during that time, the number of violation notices sent to homeowners had increased by 300%. She'd fine people for having basketball hoops in their driveways, for planting flowers in colors she deemed non-complementary to the neighborhood aesthetic, and for hosting garage sales without written permission. In one case, she tried to fine an elderly resident for having visible medical equipment in his garage because it was unsightly. Even more concerning, the records showed that several homeowners had paid substantial fines over the years for violations that were questionable at best. One family had paid $4,000 after being cited for having a play structure in their backyard that was supposedly too tall according to CC and Articus, even though the CC and Articus had no height restrictions for backyard structures. They'd paid rather than fight because they couldn't afford an attorney. Another homeowner had been fined repeatedly for having a non-approved mailbox, even though it was identical to every other mailbox in the neighborhood. Richard was right. This wasn't just about me. Deborah had been systematically abusing her authority for years, and I was the first person with the resources and stubbornness to fight back. "This is actually worse than I thought," Richard told me as we reviewed the discovery materials in his office one afternoon in June. "She's been running this HOA like her personal fiefdom, and the other board members have either gone along with it or been too intimidated to stop her. We need to make sure this stops, Gregory. Even if you were willing to walk away now, I'd advise against it. This woman needs to be held accountable." "I'm not walking away. Let's finish this." Our trial date was set for September 12th, a Monday morning after Labor Day. As the date approached, Philip Brandt made one more attempt at settlement. This time the offer was more reasonable. The HOA would rescind all fines, remove the lien, pay 50% of my attorney's fees, and issue a clarification that they had no authority over interior paint colors. Deborah would also resign as board president, though she could remain on the board as a regular member. Richard thought it was a decent offer, but I turned it down. I wanted Deborah completely off the board, and I wanted full attorney's fees. We'd come this far and proven our case in discovery. I wasn't settling for half measures. The trial started on a clear September morning with jury selection. Richard had explained that we wanted jurors who were homeowners themselves and would understand the frustration of dealing with an overreaching HOA. We ended up with a jury of 8 people, 6 of whom owned homes in HOA communities around Phoenix. The trial itself lasted 4 days. Richard presented our case methodically, walking the jury through the CC and articles, explaining why the language didn't support the HOA's position, and showing how Deborah had misled her own board members. We played portions of the Thorns' deposition testimony, where they described being shocked to learn that the violation had been for interior paint. Richard also presented evidence of all the other questionable enforcement actions Deborah had taken over the years, painting a picture of systemic abuse of authority. The most powerful moment came when Richard called me to testify. I explained what it had been like to have Deborah show up at my door threatening fines for painting my bedroom. I talked about the social isolation that followed, the stress of being sued by my own HOA, and the fundamental unfairness of being told I couldn't make decisions about the interior of my own home. I could see several jurors nodding as I spoke. Philip Brandt tried to defend Deborah by arguing that she was simply trying to maintain community standards and had acted in good faith based on her interpretation of the CC and articles. He called Deborah to testify, and that was when things really fell apart for their side. Richard's cross-examination of Deborah was surgical. He walked her through the specific language of the CC and articles, getting her to admit that it said exterior paint color modifications. He then asked her why she believed that gave her authority over interior paint. The CC and articles say all modifications, Deborah insisted, her voice tight. Interior paint is a modification. Miss Mitchell, when you presented this matter to your board, did you tell them that Mr. Vance had painted the interior of his bedroom? I told them he had made unauthorized modifications to his home. That's not what I asked. Did you specifically tell them it was interior paint? Deborah hesitated. I don't recall the exact words I used. We have deposition testimony from Brian and Susan Thorne stating that you told the board Mr. Vance was painting his house exterior. Were you aware that's what they understood? If that's what they understood, they were mistaken. Did you correct that misunderstanding at any point before they voted to support the violation notice? I don't recall. Richard pulled out a document and approached the witness stand. This is an email you sent to the board on the day before they voted. You wrote, and I quote, "We need to take strong action against exterior modifications that violate our standards." Why did you write exterior if you meant interior? Deborah's face flushed red. That was a typo. A typo. You meant to write interior but accidentally wrote exterior. Yes. And you never corrected this typo even though the board relied on it in making their decision. I didn't notice it until now. Richard looked at the jury, letting the implausibility of that claim sink in. Miss Mitchell, how many other homeowners have you cited for violations related to interior paint colors? I'd have to review the records. Let me help you. The answer is 0. Mr. Vance is the only homeowner in 4 years you've ever tried to regulate interior paint for. Why is that? Each situation is unique. Or is it because you knew your interpretation was questionable and you decided to test it on Mr. Vance to see if you could expand your authority. Philip objected, and Judge Kowalski sustained it, but the damage was done. Deborah had come across as evasive and dishonest, and the jury had noticed. The closing arguments happened on Thursday afternoon. Philip did his best to frame this as a simple disagreement about contract interpretation, arguing that the HOA had acted reasonably based on its understanding of the CC and Articus. Richard's closing was passionate and pointed. "Ladies and gentlemen, this case is about abuse of power. It's about what happens when someone in a position of authority decides the rules don't apply to them, or worse, that they can make up rules as they go along. The CC and Articus are clear. They specify exterior paint modifications. There's no ambiguity here. Miss Mitchell knew she was overreaching, which is why she misled her own board about what Mr. Vance had done. She wanted to expand her power, and she picked Mr. Vance to make an example of. She threatened to take his home, to foreclose on his property, over the color he painted his bedroom. That's not reasonable enforcement of community standards. That's harassment. It's abuse of authority, and it's exactly what HOA laws are designed to prevent. We're asking you to send a clear message that this behavior is unacceptable." The jury deliberated for less than 3 hours. When they returned, the forewoman read the verdict. They found in my favor on all claims. They awarded me $15,000 in compensatory damages for emotional distress, found that Deborah had acted in bad faith, and recommended that she be removed from the HOA board. They also found that the HOA's action had been frivolous and recommended that the court award attorney's fees. I felt tears of relief and vindication. Richard shook my hand and then pulled me into a brief hug. Across the courtroom, Deborah sat frozen, her face pale. Judge Kowalski scheduled a hearing for 2 weeks later to determine the amount of attorney's fees. When that hearing happened, Richard presented detailed billing records showing he'd spent 143 hours on my case at a rate of $300 per hour. With costs and expenses, the total came to about $48,000. Judge Kowalski awarded the full amount, plus post-judgment interest. The Sunset Ridge HOA was required to pay me $15,000 in damages, $48,000 in attorney's fees and costs, and to remove Deborah Mitchell from the board immediately. Judge Kowalski also ordered the HOA to issue a written policy clarification to all homeowners, stating that the HOA had no authority over interior paint colors or other purely interior modifications that didn't affect the exterior appearance of homes. The aftermath of the trial was strange. I half expected my neighbors to celebrate Deborah's removal, but the reaction was more muted. Some people apologized for how they'd treated me and thanked me for standing up to the board. Others remained resentful about the money the HOA had to pay and blamed me for causing the problem in the first place. I realized that you can't please everyone, and some people would rather blame the person who rocks the boat than the person who was abusing their authority. But something interesting happened about 6 weeks after the verdict. I was getting my mail one evening when Tom, my next-door neighbor who had been avoiding me for months, walked over. He looked embarrassed. "Hey, Gregory, I owe you an apology. I should have supported you instead of believing Deborah's version of events, and I should thank you, actually." "Thank me for what?" "I got a notice from Deborah back in July saying my fence was 6 inches too tall and I needed to replace it or face fines. I've been dreading the cost." But after your case, the new board president sent out a letter saying they were reviewing all outstanding violations for compliance with actual CC and R requirements. Turns out there's no height restriction on fences in our covenants. Deborah just didn't like how mine looked. They dropped the whole thing. Over the next few months, I heard similar stories from other neighbors. The new board president, a reasonable guy named Marcus Welch, went through all of Deborah's enforcement actions and dropped about 30% of them as either unsupported by the CC and Articus, or based on unreasonable interpretations. Several homeowners got refunds for fines they'd paid over the years. The atmosphere in the neighborhood slowly improved as people realized they didn't have to live in fear of arbitrary citations. Deborah moved out of Sunset Ridge about 6 months after the trial. I heard through the neighborhood grapevine that she'd taken a position on the board of a different HOA in Scottsdale. I felt sorry for those homeowners, but figured they'd have to fight their own battles. As for me, I stayed in my house with its charcoal gray bedroom and gradually rebuilt relationships with my neighbors. The experience had taught me several important lessons about standing up for yourself, about the importance of understanding your legal rights, and about how small amounts of power can corrupt people who don't have the character to wield it responsibly. Richard Chen became a good friend beyond just being my attorney. We had lunch every few months, and he always enjoyed telling the story of the HOA that tried to regulate bedroom paint colors. He said it had become one of his favorite cases to reference when explaining to potential clients why they shouldn't let HOAs intimidate them. The legal bills from the HOA eventually got paid, though it took some additional legal wrangling to collect everything. The association had to do a special assessment on all homeowners to cover the judgment, which caused some grumbling. But most people understood by then that the fault lay with Deborah's actions, not with me for defending my rights. One unexpected positive outcome was that the whole situation led to reforms in how the Sunset Ridge HOA operated. The homeowners voted to amend the bylaws to require board meetings to be open to all residents, to create an appeals process for violations before fines could be imposed, and to set limits on how much the board could fine someone without a vote of the full membership. These were changes that should have existed from the beginning, but that nobody had pushed for, until Deborah's overreach made the need obvious. I sometimes wondered what would have happened if I just complied with Deborah's initial demand, submitted an application for approval to paint my bedroom, and waited for the architectural committee's decision. Part of me thinks they would have denied it just to prove they could, which would have led to the same conflict eventually. Another part of me thinks maybe they would have approved it, and I could have avoided months of stress and legal battles. But the more I reflected on it, the more I realized that complying would have been wrong regardless of the outcome. Giving in to an unreasonable and legally baseless demand just to avoid conflict doesn't make the demand go away. It reinforces to people like Deborah that they can push boundaries, and most people won't push back. There was one final twist to the story that happened about a year after the trial ended. I got a call from a reporter at the Arizona Republic who was doing a story about HOA overreach in the Phoenix area. She'd heard about my case and wanted to interview me. I agreed, figuring that more public awareness about the issue couldn't hurt. The article ran on the front page of the local section and told my story alongside several others about HOA problems in Arizona. The reporter had done her homework and found that Arizona had some of the highest rates of HOA-related lawsuits in the country, largely because the state's HOA laws were relatively weak and gave boards substantial power without much oversight. The article quoted Richard Chen extensively and featured a large photo of me standing in my charcoal gray bedroom. The response to the article was overwhelming. I received dozens of emails and phone calls from people around Arizona sharing their own HOA horror stories. Several people asked for Richard's contact information because they wanted to fight their own battles. A state representative even reached out to say he was considering legislation to strengthen homeowner protections and wanted my input. I spent several hours on the phone with Representative David Kellerman, explaining what had happened and what kinds of legal protections would have made my situation easier to resolve. He was particularly interested in the idea of requiring HOAs to provide clear notice to homeowners about what authority they did and didn't have, and in creating a streamlined dispute resolution process that didn't require expensive litigation. Representative Kellerman introduced a bill the following legislative session called the Homeowner Protection Act. It included provisions requiring HOAs to clearly define their authority in plain language, creating a mandatory mediation process before litigation could proceed, and establishing penalties for HOAs that pursued legally baseless enforcement actions. The bill had strong bipartisan support because HOA overreach affected people across the political spectrum. I was invited to testify before the House Commerce Committee in support of the bill. Standing in the Arizona State Capitol building, telling my story to a room full of legislators, felt surreal. I explained what Deborah had done, how the existing laws had made it difficult and expensive to defend my basic rights, and why reforms were needed. Several committee members asked thoughtful questions, and a few shared their own experiences with problematic HOAs. The Homeowner Protection Act passed both chambers with strong majorities and was signed by the governor in April, about 18 months after my bedroom painting saga had started. When the governor held the signing ceremony, she invited me to attend and personally thanked me for bringing attention to an issue that affected hundreds of thousands of Arizona residents. It was one of the proudest moments of my life, knowing that my frustrating experience had led to meaningful change that would help other people. Back in Sunset Ridge, life settled into a comfortable rhythm. The HOA under new leadership functioned the way HOAs should, handling basic maintenance of common areas and enforcing reasonable rules about truly external issues like lawn care and exterior paint colors. Nobody tried to regulate what anyone did inside their homes. Several new families moved into the neighborhood, and I made a point of welcoming them and telling them about the HOA's history so they'd know their rights. I repainted my guest bedroom about a year after all the legal battles ended, choosing a warm sage green that I loved. I didn't ask anyone's permission, and nobody tried to stop me. That's exactly how it should have been from the beginning. Looking back on everything that happened, I'm glad I fought. It cost me money, time, and stress, but it was worth it. I learned that standing up for yourself matters, that legal rights are only meaningful if people are willing to enforce them, and that sometimes the right thing to do is also the hard thing to do. I learned that power unchecked inevitably leads to abuse, and that communities function best when there are clear rules and accountability. Most importantly, I learned that I wasn't alone. There were thousands of people dealing with similar problems, and by fighting my battle publicly, I'd helped create space for them to fight theirs. The emails and calls I received from grateful homeowners around Arizona made all the stress worthwhile. My charcoal gray bedroom remains one of my favorite spaces in my house. Every time I walk into it, I remember what it represents, not just a color choice, but a stand for basic property rights and personal freedom. It's a reminder that sometimes the smallest things, like choosing paint for your own bedroom, can become the catalyst for larger changes. Deborah Mitchell's attempt to expand her authority backfired spectacularly. Instead of establishing precedent that HOAs could regulate interior paint, She created precedent that they absolutely could not. Instead of intimidating homeowners into submission, she sparked a movement for HOA reform. And instead of maintaining her position of power, she lost everything she'd worked to build. I occasionally wonder what Deborah thinks about how everything turned out. Does she have any regrets? Does she understand why what she did was wrong? Or does she still believe she was just enforcing reasonable standards? I'll probably never know, and honestly, it doesn't matter anymore. What matters is that the system worked. When an HOA board member overstepped their authority, they faced consequences. When a homeowner's rights were violated, the courts vindicated those rights. It took time and money and effort, but justice eventually prevailed. The experience changed me in ways I didn't expect. I became more involved in my community, attending HOA meetings regularly and making sure the new board stayed accountable. I also became more confident in general, more willing to push back when something didn't seem right instead of assuming that people in authority must know better than me. That confidence spilled over into other areas of my life, making me more assertive at work and in personal relationships. 3 years after everything started, I'm still living in my house in Sunset Ridge with its charcoal gray bedroom, sage green guest room, and a deep blue home office I painted last month without asking anyone's permission. My neighbors are friendly, the HOA is reasonable, and Phoenix continues to be a great place to call home. The nightmare of dealing with Deborah Mitchell and her overreaching HOA board has faded into an interesting story I tell at dinner parties, though the lessons I learned remain fresh. And sometimes, when I'm painting a room or making some other change to my house, I pause and think about how easily I could have just given in to Deborah's demands. How I could have decided it wasn't worth the fight, paid some fines, and moved on. I'm deeply grateful I didn't make that choice. Fighting back was the right decision, not just for me, but for everyone who came after. That's the real story of the HOA that demanded I get approval to paint my own bedroom. It started with an absurd overreach of authority, continued through months of legal battles and social isolation, and ended with meaningful reforms that protected the rights of homeowners across Arizona. It's a story about standing up to bullies, about the importance of knowing your rights, and about how one person fighting back can create ripples that spread far beyond their original intent. The attorney who laughed when he first heard my story turned out to be exactly the right person to help me fight. Richard Chen understood immediately what was at stake and pursued the case with energy and skill that exceeded anything I could have hoped for. His laughter in that first meeting wasn't mockery or disrespect. It was the reaction of someone who recognized an injustice so clear-cut that it bordered on the absurd. That laughter gave me confidence that I wasn't crazy, that my instincts were right, and that fighting back was worth the effort. If there's a lesson in all of this for other homeowners dealing with difficult HOAs, it's this: know your rights, read your governing documents carefully, and don't be afraid to push back when an HOA oversteps. Most HOA board members are well-intentioned people trying to maintain their communities, but some, like Deborah, are petty tyrants who use their positions to control others. Those people need to be challenged, and when they are, they usually back down or get removed. The legal system exists to protect homeowners from this kind of abuse, but only if people are willing to use it. I'm sometimes asked if I would have done anything differently, and my answer is always no. I would fight the same fight in the same way if I had to do it over again. The only thing I might change is that I would have educated myself about HOA laws and my rights earlier, before any conflict arose. Going into homeownership with a clear understanding of what an HOA can and cannot do would have made the initial confrontation with Deborah less shocking and confusing. For anyone buying a home in an HOA community, my advice is straightforward. Read every page of the CC and Articles before you close. Ask questions about anything unclear, and research the HOA's history if possible. Talk to current residents about how the HOA operates and whether the board is reasonable. Look for red flags like excessive fines, frequent violations, or complaints about board overreach. These problems are easier to avoid than to fix after you've already bought the house. But if you do find yourself in a situation like mine, don't be afraid to fight. Document everything. Consult with an attorney who specializes in HOA law and stand firm on matters of principle. The stress and expense of fighting back can be significant, but so is the cost of living under arbitrary authority in your own home. Sometimes the only way to restore balance is to push back hard against those who abuse power. As I sit here now in my charcoal gray bedroom, typing this reflection on everything that happened, I feel satisfied with how it all turned out. The room looks great, my rights were vindicated, Deborah was held accountable, and meaningful reforms were enacted. It's as complete a victory as anyone could hope for in a situation like this. And the best part, I never had to get anyone's approval to paint my own bedroom. Because that was never something they had the right to demand in the first place.